Good afternoon. Good afternoon. How are you? Good afternoon, Natasha, Makira. We just wait a few minutes for the others. Good afternoon, Christina.
Good afternoon.
I need you to, if you don't have it, I'm trying to send the link now for the company's winding up. You think you can find it under the company's, under the laws of the Bahamas?
I can look. You mean like on Google search?
Yeah, go into laws of the Bahamas.
Okay.
Go under acts, alphabetical, go under C, and then you'll see the winding up amendment.
I got it.
Okay. Good. And then if you look at, just so you could know it's available, if you go under, instead of going to act, go into subsidiary. There it says legislation. Instead of acts, if you go into the next tab below, it says subsidiary by alphabetical order. Go again into C, and you should see the company rules. It says companies winding up, amendment rules 2010, and then the company's winding up rules. And then the company's liquidation rules 2012, just so you could know where it's at. For information purposes. Okay, so let's start. Anybody finish their midterm? Because I haven't received any. I know everybody is busy. Because when I look at things at the end of the week, I said, oh God, I was supposed to do this and didn't have the time. So now, let me hear what you all have to say.
I am halfway through it. My goal was to finish it this week so I could send it to you before class, but it didn't work out that way. But I am aiming to finish it today, so I could send it in.
Okay. How the capstone looking? I heard plenty fools. What is that?
Well,
yes, I'm waiting.
You see what happened?
sorry, that's my husband in the background.
Oh.
Good afternoon.
Shut up.
And he said all of that because I've been like stressing about this capstone for a couple weeks.
You don't have to stress, you just have to apply yourself. And the answers aren't that long, I think the last.
I don't even know. Okay, is there a capstone question or am I supposed to have come up with the capstone question?
No, there's a capstone question.
Oh, okay. Was it sent via email?
Let me look through my stuff. Where's everybody else who's on this class? Stay right there. Hold on, I have to look for my stuff. And then I'm on the new Gmail, so it's a different thing. I'm trying to find it. Trying to see if I could find I was so busy working on the final exam, which is ready, I must say. I'm trying to find my papers. I know you have the midterm to do. Let me see. Just have a lot of papers. And I don't see it. What's the name they're on yet? Is Makira on?
Yes, ma'am.
Did I send a capstone?
No, ma'am. Nothing came through my email.
Thank you, Makira.
My email is makiramonroe@gmail.com. I don't know if you sent it to my yahoo.com because I don't even have access to that.
Oh.
But I haven't received an email for the capstone.
Okay. So I'll send you all a capstone, which we can have that due after, the week after the exam. How that sounds?
Perfect. Ideal.
Okay.
Yeah, that'll be due the week after. Just don't forget my email. My original email was hacked. When classes first started, my email at Yahoo was hacked. So that could be where, yeah, that could be where, yeah. That's exactly what happened. Okay. So I'll send that out today. And
that's why I had thought that we were supposed to come up with our own capstone question.
Oh, no. I would normally send something to you all to do, but I think that's where what happened because my email was hacked. We were trying to get it restored. That's exactly what happened. Okay. Well, aren't you lucky?
Listen.
Thanks for teach.
I know. Because, whoo, I was stressed.
No, don't be stressed. Don't be stressed. Don't be stressed. Okay. So let's see if we can wrap this up so y'all could at least have, I could have that midterm marked along with the final exam. So don't forget now, don't turn in your midterm with the finals. Email me the midterm. And the same thing with the capstone. Email that to me also. So you only just going in to do the final exam. So should I do liquidations first? And then we look at what's on the finals, or you want to hear what's on the final first?
Liquidation first.
Yeah, let's do the liquidation first and then final exam.
Okay, all right. So everybody knows what liquidation is. It is a process and is where a company is dissolved. But there are two types of liquidation. You can have a voluntary liquidation and an involuntary liquidation. So the members themselves or the shareholders or the creditors can wind up a company. Now, you know, a company can be solvent and it also can be insolvent. So if the company is solvent, then of course, the members or the creditors appoint a liquidator. If the company is insolvent, which means that it cannot pay its debts, the creditors can apply to the court to have the company involuntarily wound up. And in that process, a liquidator is appointed. And that liquidator will act on behalf of the creditors. But they will do so under the court's discretion. So if you notice in the papers, practically, I think it's about, well, nearly every day. But you see a lot of them on Thursday and Friday paper. You would see companies in liquidation, those little small ads. Recall seeing those? Where it says a company is in liquidation. They're normally IBCs. Very small ads. And it gives you the section that they're being dissolved under and gives you the name of the liquidator. Everybody recall seeing those in the papers?
I know, and I don't really use or buy the paper.
I forget y'all don't buy the paper. Y'all don't look at the paper. Okay, but it's in the paper because the liquidations have to be published. So the objective of the liquidator is to ensure that the assets are secured, they are received, and then they are realized and then distributed to the company's creditors. Now, only if there is a surplus, then the shareholders or the members will be entitled to a distribution. So the first thing is all creditors are paid. So voluntary liquidation is where the members, they make the decision to resolve the company, wind up its affairs. Involuntary is where the court makes a winding up order on the petition of a creditor, or it could even be a shareholder who is aggrieved. I mean, a shareholder who doesn't like the way the company is being run, or there is a dispute. Remember what I said when we did the unit on shares? That's why there's always a shareholders agreement. It's recommended that they have one for when there is a dispute to know what are the next steps. So where the winding up of a company is commenced by a court order, the liquidator exercises his power under the direction of the court. And of course, they are required to obtain the consent and or authorization of the court before they enter into any transaction. So let's first look at voluntary liquidation. And you have the act there. So under Section 2 of the Ibc Winding Up Act, a company incorporated under the Ibc Act may be wound up under any circumstances, same as a CAC. So under the Companies Winding Up Act, an IBC may be compulsory wound up by the court, or it could be wound up by resolution of its members pursuant to its articles, or if it's a limited duration company at the expiration date as stated in the articles, or under the supervision of the court. So under Section 211 of the Companies Act, the Winding Up Act, a company may be wound up voluntarily if the period fixed for duration of the company expires. Again, it goes by the Articles of Association. The date is actually in the article. Or it can be wound up whenever an event occurs. And again, that's stated in the articles or the memorandum, because sometimes a company is incorporated just for a particular purpose. Or it could be a resolution requiring the company to be wound up voluntarily, and that has been passed by no more than 3/4 of the members. And those members have to be entitled to vote. And fourthly, a company could be wound up voluntarily if the members passed up a resolution to voluntarily wind it up because the company is insolvent. So under Section 212, the voluntary liquidation of a company is deemed to commence at the time of the passing of the resolution authorizing such winding up, or on the expiry of the period or the occurrence of the event that's specified in the memorandum or the articles. And notwithstanding that a supervision order is subsequently made by the court, the commencement date remains either the time of the passing of the resolution authorizing the winding up, or the expiry date that's in the articles or the memorandum. So the process for winding up an IBC is the resolution, of course, by the members or the directors based on what's required in the memorandum and articles of association, the appointment of a liquidator, then of course, the approval of the proposed plan of dissolution, the execution of the articles of dissolution. The executed articles of dissolution are submitted to the registrar for registration. The date of the articles of dissolution is the date of the commencement of the winding up. Unless, of course, the articles of dissolution provide for another date, which has to be within 30 days of registration. The liquidator takes responsibility for winding up the company's affairs. And that means that they have to gather all the assets, they have to pay all the debts, and then they have to manage the company's bank accounts. So under the IBC Act, following provisions are permissible in the liquidation: interest on debts. A winding up interest is payable in accordance with Section 90, subsection 1, on any debt proved in the winding up, including so much of such debt as represents on the remainder of the debt. So that means that if there is a debt that has been outstanding, the liquidator can pay interest on that debt. Under subsection 2, it says any surplus remaining after the payment of the debts proved in the winding up before being applied to any other purpose can be applied in paying interest on those debts in respect of the period during which they have been outstanding since the company went into liquidation. Notice not from when the debt occurred. It's from when the liquidation, when the company went into liquidation. All interest under this section rank equally, whether or not the debts on which it is payable ranked equally. And no interest shall be payable if the liquidation is concluded in less than 6 months or the accrued amount is less than $500. The next step is the liquidator advertises for creditors during the liquidation process. And that's the question I was asking you about now, whether or not you noticed the liquidation notices in the newspaper. The notice of dissolution must be published within 30 days of the registration of the articles of dissolution. The liquidator prepares a statement of account in respect to the actions and transactions in the liquidation process and forwards a copy of that to each member. The liquidator then submits a statement or notice to the registrar that the winding up dissolution has been completed. The registrar then strikes the company off the register of companies, and upon receipt of the notice, they would issue a certificate of dissolution, certifying that the company has been dissolved. The date of the certificate is the date of dissolution of the company. The liquidator then publishes a notice that the company has been dissolved and has been struck off the register in the official gazette. And that's upon issuance of the certificate of dissolution. So that's the process. Now, a company, a creditor, a member, or liquidator can, within 5 years following the date of the striking off of a company, apply to the registrar to have the name restored to the company. And upon payment of the prescribed fee and any other fees due, the company can be restored to the register. If a company has been dissolved or the period of 5 years has expired, the company or creditor, a member or liquidator can apply to the court to have the name of the company restored to the register. So what is the effect of striking off? A company which has been struck off the register still incurs liabilities. A creditor may bring a claim against the company and the court may appoint an official liquidator. Because remember now, a company under the IBC Act can be struck off if it no longer satisfied the requirements under section 14, 38, and 44 of the Act. And we mentioned that last week in class. So section 169 speaks to if a company is struck off under section 165 and remains struck off continuously for a period of 5 years, the company is then deemed to be dissolved. But of course, the registrar, if it is in the best interest of the Crown, can apply to the court to have the company liquidated and appoint an official liquidator. Any comments? No comments so far?
I'm rereading the part.
You're reading?
I'm rereading it.
Oh, okay.
Try to, yeah.
A couple minutes then.
Mhm. Okay, I got it.
You got it?
Yeah, no questions on that part.
Okay. Let me see if you could find this, because I don't think I saved this. Go in Google and put in Baron, B-A-R-O-N apostrophe S, Barron's Court, C-O-U-R-T, Holdings Limited, and Welwyn, W-E-L-W-Y-N Limited, and the Registrar General. So that's Barron's Court Holdings and Welwyn Limited and the Registrar General. Put a plus sign and put Supreme Court. Put another plus sign and put 2021. And you should have a court case that comes up that says the same thing. Let me know when you find it.
I got it.
Good. Anybody else? Found it?
Ms. Archer, you could repeat that again, please.
Okay. Barron's, B-R-O-N apostrophe S, Court, C-O-U-R-T, Holdings Limited.
I put the link in the chat too, just in case it's easier.
Yeah. And Welwyn, W-E-L-W-Y-N Limited. Okay, so let's start. Because this case is 31 pages long. So this case raises the important issue of whether the name of a company incorporated under the IBC Act, which has been struck off the register, can be restored to the register after the company has been dissolved. What do you think? Can it? The company has been struck off.
Based on the rest of that, it says that it can.
the name of, it is clear that prior to a dissolution, it says prior to a dissolution, the name of,
after the fact.
right, it says prior, remember we just read that. It said that prior to dissolution, the name of an IBC can be restored to the register under section 166. It can. So counsel for the plaintiffs, just remember who the plaintiffs are, Barron, submit that even though the current statutory regime applicable to IBCs does not provide for the restoration of dissolved companies, the court can nevertheless make an order under its inherent jurisdiction for the name of a dissolved company to be restored to the register. We just read that too, remember? They can't do it. The defendant counsel, and the defendant is the registrar, does not oppose the relief sought in this action. And he is content to adopt a neutral position in this case on the basis that the Registrar General will comply with any orders made by the court. However, he seeks a fixed cost order against the plaintiff in respect of the defendant's costs in this action. So the Registrar General says it will take whatever instructions the court gives it. So Barron's court holding was incorporated on the IBC Act on the 18th of May, 2004. Wellwyn, which is the second plaintiff, was one of its two subscribers and was also the shareholder and the director of Barron. The other subscriber was Rosencrantz Limited. Both Wellwyn and Rosencrantz Limited are owned by Lennox Payton Corporate Services Limited, and they act as nominee companies in the incorporation of IBCs for its client. Everybody understand that structure?
No.
Oh, okay. Get a piece of paper, and I want you to draw a box. And in that box, put in it Barron's Court Holdings. On the top of Barron's Court Holdings, I want you to put two boxes. So you do like a V on top of that box and put two boxes, two lines going out. In one box, put Wellwyn, and in the next box, put Rosencrantz. So now looking at the structure, you could see that Wellwyn and Rosencrantz were shareholders of Barron. You agree?
Yeah.
Okay, they're sitting at the top. Now, just below Barron, just draw a line to the side and put directors. Or director. Barron. So Barron was also a shareholder and a director. Me and Wellwyn. On the side of Barron, put a line, put director, and put Wellwyn. So Wellwyn was a shareholder and a director. Now, in the box where you have Wellwyn and Rosencrantz, you would normally put in the bracket in that box, nominee, nominee. So nominee, remember when we did the unit on directors? And we spoke about the nomineeship agreement. This is what this nominee is talking about. So now let's go back to last class. Last class, we spoke about financial corporate service providers and that they provide the registered office and registered agency services to IBCs and CACs. So Lennox Payton Corporate Service Limited has a license to offer that service. So one of the services that it offers is that it has companies incorporated under Lennox Payton, the law firm. They've incorporated companies to provide that service under their corporate services license. And those companies, Welwyn and Rosencrantz, they act as shareholders and directors on behalf of their client. That's what that relationship means. So that means that somewhere in their records, they would have recorded a declaration of trust. And in that document, it's called a declaration of trust. And then there's another one called a nominee agreement. They're formulated in different ways, word-wise. They would speak to who they are holding the shares on behalf of. So Welwyn could be holding the shares on behalf of Mr. Duke, and Rosencrantz could be holding shares on behalf of Mr. Wells or someone else. But on just looking at the structure, you cannot tell who owns the company. It's okay. Is everybody okay now?
Yeah.
Okay. So this is how the structure works when you're talking about FCSPs. So the registered office of BCH was located at the office of Lennox Payton. And that company was appointed the registered agent of Barron. So that's not complicated for you because I just explained that to you. So Welwyn held his shares in Barron on trust for the late Lord Louis Gomez del Campo Bacardi, Lord Bacardi, which I just explained to you. They hold it on behalf of someone. And like I said, it's done under a declaration of trust. And that declaration of trust was dated the 18th of May, 2004. So in February 2005, Barron was placed into voluntary liquidation and ultimately dissolved by a certificate of dissolution dated the 29th of March, 2005. Everybody understand that statement, right? Because that's the process we just went into.
Yeah.
Okay. So the name of the company was removed from the register by the Registrar General. The action was commenced by originating summons filed on the 10th of September, 2021, seeking a declaration that the dissolution of Barron is void and ab initio. An order that the name of Barron be restored to the Register of Companies. An order that Barron pay all outstanding fees to the Registrar General. An order that the Registrar General advertises the restoration in the Gazette. An order that Barron be deemed to continue in existence as if its name had not been dissolved, and any other action that the court states. So let's go back now and look at all the facts so it's in your head. When was Barron incorporated? What's the incorporation date? The 18th of May, 2004.
Oh, yes, ma'am.
18th of May, 2004. It went into a voluntary liquidation what day?
February 2005. Oh, no, 29th of March 2005.
Oh, that's what it was dissolved.
Oh, okay. So, yeah, February 2005.
Yes.
Yeah.
Voluntary liquidation. And then certificate of dissolution was dated the 29th of March 2005. Okay. So look at that date. So now they went to the court to bring an action on what date?
the 10th of September, 2021.
How many years have gone by?
Almost 10, well, 6 years. No, more than 10.
2005 to 2021?
Yeah, that's more than like 16, 17 years.
16 years.
18, 19, 20, 20, no, 7. Yeah, 16 years.
Okay. So you know under section 169, if a company has been struck off, it remains struck off continuously for a period of 5 years, the company is deemed resolved, but the registrar, if it's in the best interest, can apply to have the company liquidated and appointed an official liquidator. But this is already liquidated. So in effect, what does that mean?
It no longer exists.
There are no more assets, right?
Right.
Okay. So they're asking for a declaration that the dissolution is void. They want the company restored to the register. Any outstanding fees for those years, those
16 years.
Yes, they want that they're going to pay it. And they want it advertised that the company has been put back on the register. So this summons was put before the court by Michael Payton. Don't forget now, Lennox Payton is the registered office and registered agent of the company. So now let's go to the history of this client, this Lord Bacardi. So, paragraph 8. Lord Bacardi was a man of substantial means. According to the affidavits, his assets included the beneficial ownership of shares in Bacardi Limited, a company incorporated in Bermuda, through 2 Liechtenstein companies named Arateo Onslaught and Rantex Onslaught. Arateo was the registered owner of 739,927 shares in Bacardi and 664,295 shares of Bacardi were registered in the name of Rantex. Lord Bacardi was the beneficial owner of both Arateo and Rantex. Affidavits show that in July 2003, a fiduciary company in Liechtenstein by the name of Walpart Trust set up a trust called the Bastille Trust for the benefit of Lord Bacardi. The trustees were Lord Bacardi, Dr. Ernst Walsh, a shareholder and director of Walpart, and Louis Maudry, who was at that time Lord Bacardi's attorney in Switzerland. The Bastille Trust was intended to be a succession instrument for the benefit of Lord Monica Gomez del Campo Bacardi, Lady Bacardi, the wife of Lord Bacardi, and his only daughter, Miss Maria. The unsold shares were part of the assets of the Bastille Trust. In 2004, Lord Bacardi received advice from his Bahamian attorney, Lennox Payton, which caused him to reconsider the use of the Bastille Trust as a succession instrument for his wife and daughter. He was advised that 2 of the 3 trustees acting without him could make decisions affecting the Bastille Trust, which might be adverse to his intentions. That was unacceptable to Lord Bacardi, and he concluded that the trust did not provide the intended level of security for his wife and daughter. In those circumstances, he wished to revoke the Bastille Trust and transfer the trust assets to a Bahamian company, which he intended to incorporate. In that regard, Lord Bacardi caused Barons to be incorporated, and he wrote to Miss Gail Butterworth of Bacardi, requesting that 1, the share certificate and the registration of the unsold shares in the names of Aratero Onslaught and Rantex Onslaught be canceled. The Onslaught shares be registered in the name of Baron, and a new certificate be issued by Bacardi, showing 1,404,000 202 shares registered in the name of Barron. All of this was recorded in the affidavits that was submitted by Lennox Payton. So the law firm of Conyers, Dill, and Pearman, they acted as special counsel to Bacardi in Bermuda. They wrote to Lord Bacardi on the 12th of November, 2004, to inform him that the other two trustees of the Bastille Trust, Dr. Walsh and Mr. Modry, had directed Bacardi that he should not accept instructions from him in connection with the unsold shares. What you see happening there? You following this as I'm reading?
I'm following, and it seems like conflict.
Yes. But you see who the parties were when he was formulating the trust. The trustees were himself, Walsh, who was a shareholder and director of Walpart. And remember now, Walpart is the fiduciary company that's helping him to set up this trust in Liechtenstein. And then he had Louis Modry, who was his attorney in Switzerland. So those two gentlemen, along with Lord Bacardi, were the trustees of his trust. So those two, Dr. Walsh and Dr. Modry, had directed Bacardi that it should not accept instructions from him in connection with the unsold shares. Presumably, they were contending that acting together as two of the three trustees of the Bastille Trust, they had control of the trust assets. So you see where the first step where he started to go wrong? He established a trust where there are three trustees, and three is an uneven number. And two of them had more power than him. In view of the conflict between the instructions from Lord Bacardi and on the one hand, and of course, Dr. Walsh and Modry on the other hand, the letter from Conyers stated that Bacardi was not prepared to comply with the instructions from Lord Bacardi to transfer the unsold shares to Barron's until it confirmed who was authorized to give instructions on behalf of Arateo and Ranex. Aggrieved by the decision of his fellow trustees to block the transfer of the unsold shares to Barron, Lord Bacardi requested Dr. Walsh and Mr. Modry to resign as trustees of the Bastille Trust. They did not do so. And on the 29th of October 2004, Lord Bacardi commenced legal proceeding in Liechtenstein to remove them as trustees. Earlier on or around May 2004, Lord Bacardi had retained Mr. Claude Bushbull, a partner to the Swiss law firm of Petzoluzzi, Lecknell Party, to represent him. Approximately 8 months later, on the 23rd of January 2005, Lord Bacardi died in Monaco. At that time, the unsold shares had not been transferred to Barron's. I digress to note that Lord Bacardi had a will at the time of his death, which is dated the 8th of October 2004. And clause 5 of the will states as follows. Residuary estate. I give the rest of my property, whatsoever and wheresoever, including any property over which I may have any power of appointment of disposition, my residuary estate, to my trustee upon trust after payment of my funeral and testimony expenses and debts on the terms of the trust set out below. Kerry Langlois, Sam Esquire, and Lady Bacardi were appointed as trustees and executors. The beneficiaries under the will trust were Lady Bacardi, Miss Bacardi, that's the daughter, and any person appointed by the protector pursuant to clause 2.1 and not removed by clause 2.2. The dispositive provision of the will trust reads as follows. Any payment of the rightful income of the trust, the remaining income shall be divided into 2 equal shares and shall be payable to or for the benefit of the daughter of Mr. Gomez Bacardi, Maria Luisa Monica, and the widow of Mr. Bacardi, Mrs. Monica, in accordance with the following provisions. The whole of the share of income from Mrs. Monica shall be payable to her without delay upon receipt of the income by the trustees. The share of income for Maria shall be put in trust for her to pay her 1/3 of the income of a trust on her attaining the age of 18, 2/3 on her attaining the age of 25, and the whole of the sum on her attaining the age of 32. Income payments to each of the persons named in paragraph 1 and 2 hereof shall cease on the date of the death of that person, and for the final year shall be paid pro rata. On either the date of death of the said Monica or the 40th birthday of Maria, whichever is the latter, the trust fund shall be distributed absolutely to the said Maria Louise Monica, and the trust period shall come to an end and the trust shall terminate. So returning to the narrative, the affidavit showed that following the death of Lord Bacardi, there was a misstep relating to the legal representation of the estate of Lord Bacardi, which resulted in the dissolution of Baron. And it arose in this way. On the 25th of February 2005, shortly after Lord Bacardi died, Pasquale de Lucia Esquire of Pestalozzi sent an email to Lennox Payton, the registered agent of Baron, instructing them to liquidate and dissolve Baron. It will be remembered that under the Declaration of Trust signed by Welwyn and dated the 18th of May 2004, Lord Bacardi was the beneficial owner of Baron, and Pestalozzi represented Lord Bacardi personally prior to his death. Here is where the misstep occurred. Lennox Payton, assuming that Pestalozzi represented the estate of Lord Bacardi, carried out the instructions and proceeded with the liquidation of Baron, and subsequently dissolved the company under the plan of dissolution approved by the members, passed on the 28th of February 2005. So Baron was dissolved on the 29th of March, and at that time, Miss Bacardi, the daughter of Lord Bacardi, was 4 years old. It was later discovered that while Pestalozzi represented Lord Bacardi personally prior to his death, he did not represent Lord Bacardi's estate when they issued the instructions to dissolve Baron. I won't read the long thing in the middle there. Paragraph 23. So litigation commenced by Lord Bacardi in Liechtenstein in October 2004 relating to the trust continued after his death. In December 2008, the Constitutional Court of Liechtenstein removed Dr. Walsh and Mr. Modry as trustees of the Bastille Trust. Subsequently, in 2009, 3 other persons and Lady Bacardi became trustees of the Bastille Trust. As a result of the ongoing disputes between the parties at the instance of Lord Bacardi and Miss Bacardi, an investigation, main instance of Lady Bacardi and Miss Bacardi, an investigation was carried out in or around 2019 into their inheritance under the Lord Bacardi's will. The circumstances surrounding the creation of the Pastille Trust by Lord Bacardi, the refusal to transfer the unstalled shares to Baron, and other matters relating to the business affairs of Lord Bacardi. At that time, Miss Bacardi was 18 years old, while engaged with the provisions of Clause 15 of the will of Lord Bacardi. During the investigation, it was discovered by Lady Bacardi and Miss Bacardi that Baron had been dissolved and struck off the register. So the investigation led to a lot of litigation, 7 cases. The cases were listed in Mr. Payton's affidavit. 2 additional court cases in the Bahamas and Bermuda are foreshadowed in the affidavits. Baron features in a number of those cases, and it is expected to have a significant role in the foreshadowed cases in this jurisdiction and Bermuda. In the affidavit, Mr. Payton expresses the concern that the dissolution of Baron may nullify legal proceedings commenced by it or to be commenced by the company. Therefore, on the 21st of June, 2021, Lady Bacardi and Miss Bacardi instructed counsel to apply to the court to have the dissolution of Baron set aside and the name restored to the register. In the case of Lady Bacardi, those instructions were given in her capacity as the heir of Lord Bacardi, as executor of Lord Bacardi's estate, and as trustee and beneficiary of the trust under his will. For her part, Miss Bacardi issued the instruction as heir of Lord Bacardi and as beneficiary of the trust under his will. Any comments so far?
That's good.
So you see what is happening, especially with the two trustees.
Yes.
But what I'm trying to get is, what were those 2 trustees trying to do, knowing that all of the assets in the trust belong to Lord Bacardi? Do you think it's just that they didn't want the money, or the fees that they were being paid to move from them to the company? But the company would have still been a part of the trust. So let's go to Mr. Glinton now. Mr. Glinton is speaking on behalf of Baron. So Mr. Glinton submits that the court has an inherent jurisdiction to enable the name of a dissolved company to be restored to the register, quite apart from any statutory power to do so, which might or might not exist. So he's saying here, Glinton representing Baron, that the court itself, the Supreme Court, has an inherent jurisdiction for a dissolved company to be restored to the register. And he says that's based on the case of Reed Lehman Brothers. He said in that case, administrators of 3 Lehman entities issued proceedings seeking the determination of a number of questions arising out of the administration of certain companies. The Supreme Court in the UK had to determine whether the relevant insolvency legislation and regulations contain provisions for various aspects of the administration of the companies, and if not, whether the court had the power to make a decision with respect to the application. Mr. Glinton submits that declaring the dissolution of Baron to be void and restoring its name to the register would be consistent with judge-made rules. In this regard, he cited another case, where it was held that the court had an inherent jurisdiction to make an order to restore a company which had been dissolved, where the dissolution was caused by fraud. Additionally, counsel contends that the court can, under its inherent jurisdiction, grant the relief sought to the originating summons on the ground of mistake. He relies on 3 cases decided in this jurisdiction, that's the Bahamas. And he gave the case of Rushmore Hills versus the AG, Cato Holdings versus the AG. And he said the court held that a dissolved company could be restored where a mistake has been made. The court in both of these cases granted declarations that the resolutions of the shareholders and directors of the company to voluntarily wind up the companies and all subsequent acts were void, and ordered that the companies be restored to the register. The third case was Hyam versus the AG. An application was made to restore the name of a company on the ground of mistake in liquidating a company before all assets were distributed. The court decided that it was a just and equitable or just and reasonable that the company be restored so as to enable the distribution of assets which ought to have been distributed before the company was dissolved. Applying the dicta of Lord Neuberger in Lehman, it is submitted on behalf of Barron that the restoration of Barron would be consistent with judge-made principle, and he listed those 3 cases. And he also says, along with that would be the legislative principles of the IBC Act and the IBC Amendment Act, which allows the restoration of IBCs which have been removed from the register. In referring to the IBC Act, Mr. Glinton invites the court to rectify the apparent gap in the amended legislation by permitting the restoration of Barron. Unfortunately, I do not have the benefit of a written ruling or judgment in any of the 3 Bahamian cases setting out the reasons for the decisions. It seems that either there is no written judgment in those cases, or if there is, it could not be found by counsel. Nevertheless, all of these cases were cited in Ivanishvili with a brief description of the facts and a statement of the outcome. Mr. Glinton submitted that Ivanishvili, Rushmore Hills, Cato Holdings, and Higam all decided after the enactment of the IBC Act, and that they clearly established that notwithstanding that there is no statutory power to restore the name of a dissolved company to the register, the court has the inherent jurisdiction to do so in cases involving fraud and mistake. He referred to the fact in this case that Barron was dissolved on instructions from a law firm of Petsalusi on the belief that they had authority to act on behalf of the estate of Lord Bacardi. According to the affidavits, they had no such authority. Therefore, Mr. Glinton contends that the voluntary winding up and dissolution of Barron was based on a mistake and should be declared void, and the name of the company should be restored to the register. He submits that this is just and reasonable, given the litigation surrounding the estate of Lord Bacardi and the shares of Bacardi. And in his submission, he put it this way: the proceedings that have been recently commenced by Miss Maria Louisa Monica Bacardi in connection with the estate of Louis Bacardi is claim in which she seeks possession of the Bacardi shares, which she believes she is entitled to receive under her father's will trust. In this connection, she craves in the alternative, in section 4, page 62 of the assignment, an order that the Bacardi shares be transferred to Barron. In order for the same to be effected, Barron would have to be restored. The importance of Barron in the Monaco proceedings appear clear from the pleadings in that case, so that the ground that the company be restored for the purposes of ongoing litigation appears to have been constituted. In conclusion, Mr. Glinton submitted that it is fair and reasonable for Barron to be named as a plaintiff in this action, since it is the company seeking to be restored. He contended that it would be consistent with the provision in the repealed and the current section 166 of the IBC Act that allowed a company which had been struck off to apply to have its name restored to the register. As for Welland, it is submitted that it has the standing to bring this action as it was the director and shareholder of Barron. Under the statute, directors and shareholders have the power to dissolve. And so Mr. Glinton submits that they should have the standing to apply to the court for the restoration of the name of the company under the inherent jurisdiction of the court. So then the case goes through section 165 and 166. Now turn to paragraph 38. Paragraph 38 says a lacuna in the IBC Act was highlighted in the case of Tenancelli's Trust, where the court held that the Registrar General did not have the power under the IBC Act to restore an IBC that had been struck off the register for non-payment of prescribed fees. This was in 2009. So shortly after Tenancelli's, the court had to consider in Acadian whether under the IBC Act, the court, as opposed to the registrar, had the power to restore an IBC that had been struck off the register for non-payment of fees. It was held on the same reasoning as used in Tenancelli's that the court had no such power under the Act. These two cases seem to have engaged the attention of the legislature in March 2010, and Parliament passed the IBC Amendment Act, which amends section 165, 169, and 76, and replaces section 166 of the IBC Act with a new provision. So under the amendments, the registrar and the court are expressly given the power to restore the name of an IBC which was struck off for non-payment of fees, and thereby eliminated the lacuna identified in Tenancelli's and the Acadian case. However, another issue has arisen on the amendments introduced by the IBC Act. The new section 166 of the Act provides that if the name of a company has been struck off the register under section 1652, the company or creditor, member, or liquidator may within 5 years, immediately following the date of the striking off, apply to the registrar to have the name of the company restored. And if upon application, the registrar is satisfied it should be fair and reasonable for the name of the company to be restored to the register, the registrar shall restore the name, and upon restoration, the name shall be deemed never to have been struck off the register. If the name of the company has been struck off under section 1653B, the company, the creditor, the member, or the liquidator may within 5 years, immediately following the date of the striking off, have the name of the company restored upon payment to the registrar of the restoration fee, any license fee, the license fee in respect in amount stated, and if the period of 5 years under section 103 has expired, the company or the creditor or the member of the liquidator may apply to the court to have the name of the company restored to the register. So this section does not contain an equivalent provision to repeal section 166 subsection 3, which specifically conferred on the court the power to restore the name of an IBC to the registry after it has been resolved. The absence of such a provision in the IBC Act means that currently in the Bahamas, there is no statutory power to restore the name of an IBC to the register after it is dissolved. Everybody got that? Yes?
Rereading that particular section.
Okay, read it. Let me see if I can find my...
I read it.
So you see how important it is when you looking at legislation, you have to read, especially if you're on the legal side, because when there are amendments to the legislation, you got to look at the old provision, the new provision, and then you also have to look at cases that were brought before the court to make sure that the amendment addresses all of the issues and that the new amendment doesn't remove provisions that were there before.
So does this, okay, so it means then that they weren't able to get the name restored?
We didn't get there yet.
Oh, okay, I ahead of myself, sorry.
Yeah, we're gonna have to skip some pages because this is only page 14, that's up 31. This case is 31 pages long.
How long did this case take to like be ironed out?
Well, it started from the death of Lord Bacardi.
In the Bahamian court?
This is done, let me see. When did he start? Let me see if I can get a date, because we're in 22, right? And this is dated 2021. So let me see. Yeah, 2021. Look on
so it just took the entire year, last year, to get it.
Yeah.
Resolved. Though there were things happening prior to.
In other jurisdictions.
Right, okay.
Because don't forget now, because the shares were not transferred to Barron, the shares would have been sitting in that trust. So they had to get the shares moved to Barron, so they would have been able to inherit. In order to do that, they had to go through all of the other courts and all of the other jurisdictions because they're trying to pull, the wife is trying to put all the assets together. Don't forget, when he died, the daughter was 4.
Right.
She's now over 18.
And we had read earlier where he was, he had removed the other 2 trustees.
No, he wanted to. They refused.
But he died before the courts passed that they be removed.
Yes.
Oh, that's what's happened. Okay. Just was making sure.
Then the court appointed 2 other trustees. But of course, again, the shares hadn't been moved. Now the lawyer who he was seeing, because remember he wrote his will like 5 months before he died. That lawyer that he was seeing thought that he would have been in charge of the estate of Lord Bacardi, but he wasn't. And he sent instructions to Lennox Payton, telling Lennox Payton to put the company in voluntary liquidation and dissolve it. But the shares hadn't been transferred yet. So see, he says here in paragraph 42, Mr. Clinton, he says, I observe parenthetically that this position is anomalous and is out of line with the legislative regime for IBCs in most jurisdictions which operate as international financial centers. In 2000, through section 166, subsection 3 of the IBC Act, the court was specifically given the power to restore the name of a dissolved IBC. In any view, it is unlikely that in passing the IBC Act in 2010, which was directed at curing the casus omissus identified in Tennis Shelley's and Arcadian, it was intended to take away that power. So you see what I'm saying? He's saying that that power was in the original piece of legislation when it was crafted in practically every international financial center. But after those two pieces of legislation found that there was a loophole, they did an amendment. But he's saying that he think it was just like an oversight, that they didn't put that piece back in there. So under the IBC Amendment Act, the repeal and replacement of section 166 was consequential to the inclusion of sections 3A and 3B in 165. In introducing these consequential amendments in the new section 166, the power to restore the name of a dissolved IBC to the register, which was previously existed under the repeal section 166.3, was for unknown reasons not included. It seems to me that this was an oversight, but this is a matter for Parliament. There is no ambiguity here, which can be resolved by the court through the application of established principles of statutory interpretation. It is clear that the power for the court to restore the name of a dissolved IBC to the register was contained in section 166, subsection 3 of the IBC Act. And it is similarly clear that this power was repealed and not replaced in the new section 166 under the IBC Amendment Act. If indeed this was an oversight of the draftsman, it is for Parliament to correct it by the appropriate legislative intervention. So based on the current legislative landscape as outlined above, Mr. Clinton properly conceded that there is no statutory power in the Bahamas for the court to restore the name of Barron, which has been resolved, to the register. For this reason, Barron's and Wesley have grounded this action in common law. So common law, remember, means case law. So Clinton cannot argue on behalf of Barron and Welwyn that Barron should be restored to the register based on section whatever under the IBC Act, because it doesn't exist. So the only thing he can argue is based on cases. So what happens next is that the court then looks at its inherent jurisdiction based on fraud. Because remember, based on the common law cases that he brought forward, he said that a company can be restored to the register based on fraud or mistake. So from paragraphs 45 to 77, he goes on to speak about the court's inherent jurisdiction for fraud. And then from paragraph 78 to, I didn't make a note of the last page, 78 to 90, he speaks to mistake. So what Mr. Clinton is doing is that he's building a case and he's letting the judge see, going through each one of the cases. for the judge then to decide whether or not he's going to grant permission for the restoration of Barron to the register, even though it has been dissolved, whether he's going to do it on the court's inherent jurisdiction by mistake, or if he's going to do it based on fraud. So let's go on. Let's try mistake first. This mistake is shorter, okay? So the evidence of Mr. Barron does not show that there was any fraudulent activity which caused or led to the dissolution of Barron.
Wait, which number? Because I had scrolled up.
Page 24.
Okay.
Yeah, because remember I said from paragraphs 45 to 77 is where they speak about fraud, but we know there was no fraud. So that's why I skip over the fraud section. So, rather on his evidence, there is clear case of mistake. Lennox Payton Corporate Service acted on instructions to voluntarily wind up and dissolve the company from a party who it thought was authorized to act on behalf of Barron, when in fact, that party had no such authority, and we agree to that. The affidavit showed that Lord Bacardi was the beneficial owner of Barron, and prior to his death, he wanted to transfer the unsold shares to that company. There is no indication that during his life, he changed his position on that subject and wanted to dissolve Barron. Similarly, after his death, there is no evidence to suggest that those legally responsible for his estate and therefore lawfully able to give instructions in connection with Barron ever wanted to dissolve Barron. In these circumstances, I turn now to consider whether the court has an inherent jurisdiction to restore the name of Barron to the register, not on the ground of fraud, but on the ground of mistake. And if so, should it do so in the circumstances of this case? In considering the judgments of the English Court of Appeal in the case of In Re Pinto and in Re London and Caledonian, it seems to me that the primary basis of the decisions related to the interpretations of Section 142 of the 1862 Act. The main point in each of these two cases focus on whether the affairs of the company had been fully wound up. When the liquidators presented their final accounts at the general meeting convened pursuant to Section 142, it was contended that if that was not the case, there would be no deemed dissolution under Section 143 of the 1862 Act, and therefore the court could make a compulsory winding up order. In both cases, the court declined to go behind the deemed dissolution under Section 143. The lead judgment in both cases was given by Lord Justice James in Re London and Caledonian. He summarized the decision in Re Pinto, and it bears repeating. What was decided in Re Pinto was that we could not put upon these words, as soon as the affairs of the company are fully wound up, in Section 142 of the Companies Act 1862, the construction contended for, namely, to make that a condition precedent and construe it to mean that everything had been done which was to be done. We must put some practical and sensible meaning on the words. And in my opinion, they mean as far as the liquidators can wind them up. That is, when the liquidator has done all that he can to wind up the company, when he has disposed of the assets as far as he can realize them, got in the cause as far as he can enforce them, and paid the debts as far as he is aware of them, and has done all that he can do in winding up the affairs so that he has completed his business so far as he can, and is functus officio. In my view, that was the basis of the decision in Re Pinto, together with the fact that the court held that Mr. Key was stopped from challenging the validity of the dissolution. Lord James stated that in the present case, I am of the opinion that the petitioner, that is Mr. Key, is stopped from disputing the validity of the dissolution. Lord Justice Cotton stated that I am of the opinion that there has been a complete assent by the creditor, that is Mr. Key, to the voluntary winding up as to preclude him from attempting to impeach it. And again, the end of the judgment, that I come clearly to the conclusion that Mr. Key assented to the winding up, and it is out of the question that he should be allowed to come after a lapse of 4 years to impeach proceedings to which he assented at that time. So he goes in paragraph 63, the judge says, I understand the decisions in Re Pinto and in Re London and Caledonian in this way. The words, as soon as the affairs of the company are fully wound up, in section 142 of the 1862 Act are to be taken to mean as soon as the affairs of the company are fully wound up, as far as the liquidator can wind them up. And so he has completed his business so far as he can and is functus officio. Once that has occurred and the meeting under section 142 has taken place to present the liquidator's final account, the liquidator has sent in the return to the registrar under section 143, and the 3-month period set out in section 143 has expired. The court has no power to go behind the dissolution except on evidence of fraud in connection with the proceedings. A mistake merely as to the omission of some formality, some creditor not making a claim, or some asset being undiscovered would not be enough to go behind the dissolution of the company. It seems to me that in those two cases, the court was not considering a case like the one before me, where the entire voluntary winding up and subsequent dissolution of the company was based on a mistake, in that they had been put in a train and carried out by Lennox Payton on the instruction of a party who was not authorized to act on behalf of Barron. So you see how the judge is now making the distinction between the cases. He's saying that the cases that presented, the common law cases, spoke to maybe one asset not being wound up or not added in, or maybe one creditor who's saying that he wasn't included. But he's saying this matter now with Barron is different. He's saying that the entire voluntary winding up and the dissolution, the whole thing was a mistake. He said, on these facts, the mistake in which this case is vitiating element in the circumstances surrounding the dissolution of Barron, thereby leaving it open to the court to declare the dissolution void ab initio. Adapting the language of Lord Justice Bagalay in Re London and Caledonian, the mistake by Lennox Payton in purporting to act for Barron when it had no actual authority to do so is a reason why the voluntary winding up and dissolution of Barron should be undone. And there should be some way of setting aside these proceedings. So he goes in paragraph 90. He says, since 2010, when the IBC Amendment Act was enacted, which did not contain an express power to restore a dissolved IBC, there has developed a body of common law in this jurisdiction, recognizing the court's inherent jurisdiction to restore a dissolved IBC on the ground of mistake. Unless required to do so by an appellate court, I would not be inclined to hold that all of those cases are wrongly decided. Even if that was the case, it would not, in my view, relate to the case before me, which involves a wholesale mistake about the entire winding up and dissolution process. The facts in this case are quite unlike any of the earlier cases which were cited. I am mindful of the lapse of 16 plus years between the dates of the dissolution of Barron and the date of commencement of this action. This would normally be a formidable and perhaps an insuperable obstacle to the granting of relief sought in this action. However, in this case, the delay, albeit very long, must be considered in the context of the fact that Ms. Bacardi was a minor until 2019. And also that on the evidence, she and Lady Bacardi did not discover that Barron was dissolved until in or around 2019. As a result of investigations which are carried out into the Bastille Trust and their inheritance under the will of Lord Bacardi. On these facts, I do not regard the delay as a bar to the orders which are sought in the originating summons. The second plaintiff in this case, Welwyn, is the registered shareholder and director of Barron, which is the first plaintiff. I accept the submission of Mr. Clinton that Welwyn has the legal standing to bring these proceedings, seeking the relief in the originating summons. It may well be that Barron itself also has standing to bring this action, grounded in common law, but I need not consider this point in view of my decision on Welwyn. So the judge concluded, there is pending and foreshadowed serious litigation concerning inter alia Barron. The affidavit of Mr. Payton summarized the nature and scope of the disputes and claims relating to the matters pertaining to Lord Bacardi and his estate. Bearing in mind the circumstances of this case, it is my view that it is fair and reasonable that the name of Barron be restored to the registrar so it can pursue any claims which it may have in connection with the Bastille Trust, the shares in Bacardi, the estate of the late Lord Bacardi, and all other related matters. So in all the circumstances of this case and exercising my discretion, I make the following declarations and orders. One, a declaration that the dissolution of Barron's Court Holdings Limited is void ab initio. An order that the name of Barron Court Limited be restored to the register for the limited purpose of commencing, defending, or joining in legal proceedings in any jurisdiction in connection with the Bastille Trust, the shares in Bacardi, the estate of the late Lord Bacardi, and all other related matters. An order that the Barron's Court Holdings Limited pay all the standing fees to the registrar, and an order that the Registrar General advertise the restoration aforesaid in the Gazette. An order that Barron's Court Holdings be deemed to continue in existence as if its name had not been dissolved, and an order that Welwyn pay to the defendant the fixed sum of $2,500 as costs in connection with these proceedings. And that was done by the Chief Justice, Sir Brian Murray. Comments?
Why did he have to pay? Is it because he signed off on the dissolution?
Well, they had and the shareholders. They brought the action. They're the ones that brought the matter, you know.
Welwyn.
Yes. Welwyn were the directors and the shareholders of Barron. So they actually were the right party to bring the matter to the court, even though they had added in Barron. They were really the ones to bring the matter before the court.
For the name to be restored.
Yes, because don't forget, just like you were saying in the beginning, they were the shareholders and the directors. So they're the ones who, following the instruction, had the company wound up voluntarily.
Oh, so they're the ones that had to pay for the mistake?
Yes.
Wow.
But who else was going to pay for the mistake?
I thought patent.
Well, when is patent?
That's true. That's okay.
Well, when is patent? That's their nominee company that acted as shareholder and director. Remember?
Right. I have the chart.
Right. Because even though if you look at this, if you wanted to take this even further, they could actually sue Wellwin because they, being the registered agent, should have ensured that the instructions that they received was from the right body.
So who could have sued Wellwin? Byron?
No. What your name is?
Oh, the Bacardis
Yes, the Bacardis.
could have sued Wellwin and Patent.
Uh-huh. Because that's some long years waiting for your money now.
And so the real reason why they needed to reinstate Byron is so that she could actually get the shares that were supposed to be transferred.
Yes, because those were his instructions, that the shares should be transferred to Byron.
But remember, because Byron wasn't in existence, she couldn't get it.
Right.
So what were the long-standing effects to this matter to Lennox Patent? Were there any?
What do you mean?
Because of this mistake.
These things aren't publicized. This is the extent of this right here. So if you don't read, you would never know.
That's true.
Yeah.
Wow, because that's a really big, it's a small thing, but it was a big thing.
And if you're working in this corporate world, something like this is important to point out. Instructions every day. But who did the person that the lawyer that they took instructions from didn't have the authority to do so?
And he was a representative of Lord Bacardi.
Only on a personal capacity, not under his estate. Because remember now, when you're living, you can go see any attorney, When a different law comes into effect then. So if you die and you leave a will, automatically your executor and your trustees in that will take over.
Right.
So automatically his wife took over.
Right.
Right. Not him. Not that lawyer.
So what was or we would never know then what the intent was for the lawyer to try and close off the company?
What do you think it is? To get paid?
To get paid?
Yes, because as far as he's concerned, Lord Bacardi came to him, right? For whatever matters. Now he heard that Lord Bacardi died. So that means that he took that opportunity to wind up the estate of Lord Bacardi. He's going to get paid a fee.
To wind up, even without permission?
He assumed he had permission, yes, but I guess he's saying, well, I'm the first rabbit in the hole, and I was the last person to see him, so let me wind up his affairs. But he didn't have no such authority.
But that ain't fraud.
Not really. That's just business.
That's business?
Yeah. Because he wasn't trying to get it to take the assets. To me, that's just greed.
Wow. And no penalty for that?
Well, then again, it depends if Lady Bacardi and the daughter intends to make a complaint to the Bar Association. If they don't, then no.
Because that's not malpractice.
It has to go before the disciplinary tribunal.
Because that's a lot of years and probably a lot of money there to spend just to get.
They may do it. They may do it.
That's last year.
That's 16 years.
That she had money laying in limbo but couldn't. Wow.
That's a lot. That is a lot.
So, but because of this, though, they would have reinstated the clause that said that the name couldn't be added back. They would have fixed that.
Oh, I don't think they fixed that since then. This just happened in last year. This case was just heard in 2021.
Right. Okay.
Never made any amendments.
Oh, so presently, according to the IBC Act, the name can't be restored.
No.
But if something like this were to happen again, they could pull this case.
And you'll have to align it with the other common law cases.
Right.
But you know, weighing heavily on this also is the substantial means of Lord Bacardi. We're not restoring a company to the back to the register for $5.
Oh, of course.
Okay then. All right. So
yeah,
even though it appears to be quite simple, you're talking about a man with how he put it? Substantial means. So you're not talking about a little bit of money. So there are always other factors that you take into consideration that are not written.
That man was old. Sorry, I Googled him. Yeah.
Just to ask if any of you Google him while I was reading.
Say again?
Just about to ask if anyone had Googled him.
Yeah, he was old with a young wife.
Yes, because she was only, little girl was only 4.
Wow. He was really old.
Did they give his net worth?
I didn't look for it, but it probably here somewhere. So okay, so who's now the owner of, because he would have been pretty much the founder and owner of Bacardi then.
Yeah.
The whole Bacardi brand.
Monica is who? His wife or daughter? Can't remember.
I can't remember. I think the daughter.
Monica's his wife. So he would have been the owner of Bacardi. He was the great grandson of the original Bacardi. Got that?
Oh, Lord Bacardi is the great grandson of the original Bacardi?
Yes.
Wow.
And he was a billionaire.
More money.
He was a billionaire.
Of course.
And the wife is estimated net worth is 5.5 million.
5.5 million, that's it? Into present date?
Let me see what date that was. That was just done last year.
So the daughter probably has more net worth then.
You forget he gave the breakdown, you know. You forget? There's a paragraph with the big, let me see. When the daughter gets, okay, paragraph 16, page 6. Let's start from page 5.
Okay.
He says here, okay, he says that after you pay off all of his expenses, he left the rest in trust. And then he says the remaining income shall be divided into 2 equal shares between, for the benefit of the daughter.
Mm-hmm.
So, and this is how he did the provision. The whole of the share income for Mrs. Monica. So any income from the assets, he says the whole of that is payable to her without delay. So whatever income was sitting in the trust from the assets, that goes right away. Then the share of income for Maria, that's the daughter, is to put in a trust. She get 1/3 when she's 18. So think about it. The shares and the other company, the R1, she hasn't received that yet because it was never transferred into the company. So she's already over 18. She's supposed to get 2/3 when she's 25. So most likely, the asset should be there. And then the whole of whatever is left, she gets at the age of 32. Along with any income. Then he says here that income for the 2 of them will cease.
At the completion of the trust.
On either the date of the death of Monica or the 40th birthday of his daughter, whichever one is the latter, the trust fund should be distributed absolutely to the said Maria, his daughter, and the trust shall come to an end. Because really it's the daughter that's fighting. And he was a Cuban. And Bacardi is the largest alcohol brand in the world. And then he became a British citizen. He was 72 when he died. Oh, when Fidel Castro came to power, that's when they left.
Child, I leave too.
Let me see. I'm trying to look at this picture, but I can't see it. They live in Monaco, the daughter. So there you go. So you see, even in the financial corporate service, just like in banking, you really have to check. You can't just take things for granted when you receive instructions. And remember with that refusal with the first 2 trustees, and even though they had hired another attorney to deal with the matter, the attorney said that he wasn't going to do any instructions until he has to confirm who has the authority to transfer, to give him instructions to have the shares transferred. Lennox Payton should have really gotten a legal opinion as to whether or not this man had the authority, knowing that those shares were pending. You know what I mean? They incorporated a company. Right. Purpose of having these shares transferred. The man died. The shares were not transferred. I would have gotten a legal opinion to see whether or not this person is authorized for me to dissolve this company, saying that the shares were never received.
Mm. So had the company not been reinstated, that would it have gone back to the original trust?
Yeah, yeah, because now it's hanging in limbo. That means the courts in Liechtenstein would have to make a decision. But then if we would have done that, you really would not have been doing justice to the client.
Mm-hmm. Mm.
And so the lawyers would have to really, really base their decision probably on even more common law cases to try to get around the fact that the court have an inherent jurisdiction and that they can exercise that jurisdiction and having the company restated. All right, so involuntary liquidation. This is the winding up and dissolution of a company incorporated under the Ibc Act. And you could be wound up by the court if the company has passed a resolution requiring the company to be wound up by the court, or the company does not commence its business within a year after it's incorporated, or the company is insolvent, or the members are reduced in number to less than 2. The court is of the opinion that it is just and equitable that the company be wound up, or a regulator petitions for the winding up of a company. And then, of course, the license is suspended or revoked. Section 190 of the Winding Up Act states that an application to the court for the winding up of a company can be made by petition by either the company after passing the resolution, or it could be any creditor, any contributory or contributories, or a relevant regulator. Or it can be done where the articles expressly provide the directors to wind up the company without the sanction of the resolution passed at a general meeting. An application for winding up shall be determined by the court within 6 months of it being made, unless the court is satisfied that special circumstances justify an extension not exceeding 6 months. Upon hearing the winding up petition, the court may dismiss the petition, adjourn the hearing conditionally or unconditionally, make a provisional order, or make any order that it thinks fit. But the court should not refuse to make a winding up order on the ground only that the company's assets have been mortgaged or charged to an amount equal to or in excess of those assets, or that the company has no assets. The role and responsibilities of the official liquidator and the procedure for winding up under the supervision of the court are also settled in the Company's Winding Up Act. So similarly, under the CAC, a company can be wound up voluntarily or involuntarily. It can be done by compulsory by the order of the court. It can be done voluntarily by resolution of the company. An event has occurred, or if there is a fixed period for the duration as expressed in its articles of association. And of course, it can be under supervision of the court. So circumstances under which a company will be wound up by the court is if the company has passed a resolution saying it's to be wound up. The company doesn't commence a business within a year. If the company is insolvent, members are reduced to less than 2. The court is opinion that it is just and equitable that a company should be wound up, or a regulator petitions for the winding up of a company over which it has regulatory authority. And of course, a company may be voluntarily wound up when the period the fixed period or the duration as settled in the memo and arts expires, or if an event as stated in the memo and arts occurs, or it could just pass a resolution by a majority of not less than 3/4, or if the company resolves by resolution that it wants to be wound up because it is insolvent. So the process for winding up a company under the CAC is, of course, there is a resolution to voluntarily wind up the company. You have an automatic commencement by the liquidator, and that's done based on the memo and arts. If not, then the directors convene a general meeting to appoint a liquidator. Consent to act is filed with the registrar, where the liquidator is appointed and at the general meeting. Appointed at the general meeting. Once a voluntary liquidator is appointed, all the powers of the director cease. A director or officer of the company may be appointed as a liquidator. A voluntary liquidator may be removed by a resolution passed by a general meeting of the company. A voluntary liquidator may resign by notice of resignation with the registrar. Within 28 days of the commencement of voluntary liquidation, the directors shall file a notice of winding up with the registrar, file the liquidator's consent to act with the registrar, file the director's declaration of solvency with the registrar, and in the case of a company carrying on a regulated business, they will serve notice to the winding up to the regulator. They'll publish notice of the winding up in the Gazette, and that declaration of solvency, it means it's a voluntary or affidavit in a prescribed form. And what it does is it gives the full inquiry into the company's affairs that are being made to the best of the director's knowledge and belief, and that they will pay all of the debts together with interest at the prescribed rate. So in the event the voluntary winding up continues more than 1 year, the liquidator shall summon a general meeting of the company at the end of the first year after the commencement of the winding up, and at the end of each succeeding year. And such meeting shall be held within 3 months of each anniversary of the commencement of the liquidation. At each meeting, a report and account of the liquidator's acts and dealings and conduct of the winding up shall be presented. And each report must contain information of the rates at which the liquidator's remuneration is calculated and particulars of the work done. 21 days before the final meeting, the liquidator shall send a notice specifying the time, place, and object of the meetings to each contributory as per the company's articles and published in the Gazette. As soon as the company's affairs are fully wound up, the liquidator shall call a general meeting to lay before the directors a report and account of the winding up, showing how it has been conducted and how the property has been disposed. And then 7 days later, they must make a return to the registrar, specifying the date upon which the meeting was held and confirmation of the quorum, particulars of the resolution, and if any passed at the meeting. An application is made to the court by a voluntary liquidator or contributory if there are any questions relative to the winding up of the company. If the court is satisfied and accedes to the application, an order may be issued. Within 7 days, the voluntary liquidator must forward a copy of the order to the registrar, who shall enter it into the records. And the voluntary liquidator is paid from the company's assets in priority all other claims. The remuneration is fixed and payment is authorized by resolution of the company. So you notice that the CAC is a much longer process. So if you look in the Companies Winding Up Amendment Act, Section 184, it speaks to the alternative modes of winding up. It says the company may be wound up compulsory by order of the court, voluntarily. Section 185 speaks to jurisdiction of the court. The court has jurisdiction to make a winding up in respect of an existing company, a company incorporated and registered under the Act, a company incorporated under any other law, and a foreign company which has property located in the Bahamas, is carrying on business in the Bahamas, or is registered under Part 4. Then Section 186 speaks to circumstances in which a company may be wound up by the court. And that can happen if a resolution is passed. Like I said earlier, it's insolvent, members are less than 2, the company doesn't commence business, or by the regulator. Section 187 gives you what insolvent means. That is that a company is unable to pay its debts as they fall due, or the value of the company's liability exceeds its assets. Then Section 188 speaks to the definition of inability to pay its debts. And then Section 190 speaks to the application for wound up, which means an application to the court for winding up of a company shall be by petition, presented either by the company itself, a creditor, a contributory or contributories, or the regulator. Then it speaks in 191 to the powers of the court. Upon hearing the winding up petition, the court may dismiss the petition, adjourn the hearing, make a provisional order, or it can make any order that it sees fit. So the notice of a winding up order, Section 194, when a winding up order is made, the liquidator should file a copy with the registrar and of course publish a notice in the Gazette. Section 195 speaks to the commencement of winding up by the court, and 196 speaks to the company's statement of affairs. Section 199 speaks to the liquidator's appointment, powers, and termination. Qualification and remuneration. Under 204, remuneration, it says the expenses properly incurred in the winding up, including the remuneration of the liquidator, are payable out of the company's assets in priority of all other claims. And then Section 205 speaks to the duties and the functions of the liquidator. Section 211 speaks to the voluntary winding up of a company, when it can commence, and the effect of on the voluntary winding up on the business and the status, the appointment of the voluntary winding up of a liquidator, the qualifications. It says in Section 215, any person, including a director, officer of the company, may be appointed as a voluntary liquidator. And of course, the voluntary liquidator can be removed, and he can also resign. And Section 218 speaks to the notice of voluntary winding up within 21 days of the commencement. They have to file the notice to the registrar, file the liquidator's consent, file the director's declaration of solvency. Did anyone look at this section of the act before?
No, ma'am.
No.
After all of these years, go to section 237. 237 speaks to preferential debts. It says, notwithstanding anything contained in this act, in the winding up, there shall be paid in priority to all other debts. All rates, taxes, assessments, or impositions imposed or made under the provisions of any act, including sums in respect of duty and penalties payable under the Customs Act, fees payable under the Companies Act and the Companies Winding Up Act, any duties and penalties under the Stumps Act, and any other fees that are due to a regulator. That's the first priority. That's the first thing that comes up. Then is any sums that are due to an employee, whether employed in the Bahamas or elsewhere. That includes the salary, the wages, and the gratuity. Then, and that has to be accrued during the 4 months immediately preceding the commencement of the winding up. All wages of any workman or laborer in respect of services rendered to the company during 2 months before the relevant date. Any sums payable to the company on behalf of an employee in respect of medical health insurance premium or pension funds, and where a contract of employment has been terminated as a consequence of the company winding up, any sum due by the company to any former employee in respect of severance pay and earned vacation pay. Unless the company is being wound up voluntarily, merely for the purpose of reconstruction or amalgamation with another company, or unless the company with insurers with rights capable of being transferred to and vested in the workman, all amounts due in respect of personal injury to workmen accrued before the relevant date. And so they say the debts that I just mentioned, they rank equally among themselves and they have to be paid in full unless the assets are insufficient, in which case they shall abate in equal proportion. And so far as the assets of the company available for payment of general creditors are insufficient to meet them, have priority over the claims of holders of debentures under any floating charge created by the company, and be paid accordingly out of the property comprised in or subject to that charge. So that means that that last part I just read, which means that say you have staff salaries to pay and the company is being wound up and the assets, the liquid assets are insufficient, but let's say the company has a loan with a bank and the assets that cover that loan are those in the company. What the act is saying is that because you owe salaries to your staff, the amount that's outstanding to your staff is taken from that asset held by the bank before the bank takes whatever's their share.
Suppose you don't have a loan and at least the company doesn't have a loan but owes salaries, where would the money be pulled from? Or is that just going to be considered a loss?
It's a loss if they don't have any more assets.
Ooh.
Mm-hmm. So let's just say salary is owed, like you saying, and somebody advanced the company that money to pay. Then that person then becomes a priority in terms of whenever there is money. And they say here under subsection 6, if there is like a group of people who have not been paid, it should be sufficient proof if one for all such claim is made by some persons on behalf of all. So what you'll do is like a class action suit for everybody just bring one action. So under section 238, it says, notwithstanding section 232, or that a winding up order has been made, a creditor who has security over the whole or part of the assets of a company is entitled to enforce his security without the leave of the court and without reference to the liquidator. Where the liquidator sells assets on behalf of a secured creditor, he is entitled to deduct from the proceeds of the sale a sum by way of remuneration equivalent to that which is or would be payable under section 204. So remember this act came in after the whole Bahama case. And they actually enacted this whole winding up rules. All right, now let's see what's going to be on the final. I had it here, now it's disappeared. Again. I can start by telling you what's in my head. It has two parts. That's the first thing. Part A and a part B. You can let me know if you want part B. I could just press delete. Part B has 10 multiple choice questions worth 2 points each. Should I keep it or should I throw it away?
We'll keep it.
Oh, wonderful.
I mean, what do you think, ladies?
It depends, because it might add up.
Yeah, let's see what's part A looking like. Tell us
what is part A?
We need insight.
Oh God, what does this would need insight? What does that mean?
If I be truthful, I would like to know all of the questions beforehand, but you can't do that.
Me too.
I would just like to know exactly.
You said you can't do that. You can do all things to Christ. Sentence you.
Well,
she can. Yeah. She can do it. She can.
You could literally just give us all the questions verbatim, so we could come ready to ace this. Plus, what you looking for in the response.
All of that?
I approve what she
no,
said.
No, she pushing it. No, man, come on now. She can't do all of that.
No. In terms of like, I don't know, because if you give us a point, like amount of points that it worked, then we know exactly. We'll know exactly how much attention needs to be paid to each question.
Each question is worth 20 points.
What?
Mm-hmm. That's
okay.
First.
And we just focusing on the principles, or it's like case study mixed in there?
It's everything mixed up together.
Is it an open book exam?
Of course not.
Oh, God.
No. All right. One question. So part A has, right now it has 6. I may probably add 2 more. You choose 5. Now,
wait.
So
we get to choose the questions we want to respond to? And we would have to, okay, go ahead, keep on.
Okay, and then for part B, remember I told you it's 10 multiple choice questions. So you can choose 4 out of part A and then choose part B for your 5th question. Understood? So you don't do 5 in A and plus B. You do 4 in A and then you can choose B.
Oh, okay. So we have to answer 4 questions out of part 8.
If you wish. You may just wish to do 5 out of part A and that's it. Be mindful that they're multiple choice. There were 2 points each, so it's 20 points. So in last class, we spoke about financial corporate service provider. And remember, we went through the statutory document that a registered office should maintain. And we also discussed the annual filings that are due under a CAC versus an IBC. That's one question. One question, 1, 2, 3. We'll have, this other question has 4 parts relative to liquidation. You should know the different types of liquidation. You should know the order when the liquidator is distributing assets, which we just did. And you should know the process for winding up an IBC, voluntary,
Do we have to, we don't have to pull case studies, do we? Or
no,
okay.
Not for this liquidation one. This one is just stating what it is. So you should know the different types, the order to distribute assets, which is done by the liquidator, the process for the voluntary winding up of an IBC,
Just an IBC, not IBC and CAC.
no, they're separate. I'm separating it.
Okay.
And then the process for winding up a CAC. So you can see it has, that's 4 parts to it. So you know that means that there's 5 points each. So you don't need to write a whole epistle. Then there's a question on directors itself. Remember when we did that chapter on directors, we spoke about directors and their duties. So this question is on directors and their duties under the CAC. The next question is another liquidation question. And it has 3 parts. Because remember, you're choosing. So this one is on, let me see. Okay, so This one on liquidation, one of the parts speaks to who can be operating the company once it goes into liquidation. In particular, the directors, what can they do and cannot do? And again, it has a part on the priority for payment of outstanding debt. Similar to the one I gave you before, just worded differently. The next question is, remember we did the shareholders agreement and we went through the whole article and we spoke about what is a shareholders agreement, why one should be drafted. And then it also spoke about the provisions that should be within any shareholders agreement. So there's a question on that. There will be a question on the case of Barron, what we just did today. Barron Court Holdings and Willen versus the Registrar General. I'm going to write a question on that.
Wait, you said Barron, the same one that we did today?
Today, yes.
Okay.
I'm going to write a question on that. The next question is on a clause in the Articles of Association of a public company. Remember, a public company is those that are listed on the stock exchange, where they are investors, which can be individuals or they can be companies. So this is I'm giving you a provision in a public company article. And then I pose two questions to you. I'm asking you, looking at that provision, what does it really mean? And two, what can the person who's been appointed, what can they do? And just hold on one sec. Let me tell you what the last one will be on. I had one more, but I just couldn't decide because I wanted to give you on more than one. Okay, I'll give you one on confidentiality and data protection. So you'll have 8. You can choose 5 or you can choose 4 and then do part B.
But if we answer all.
So why are you answering all? I only taken the first 5. Why you answering all?
Because, listen, hear me out. If 4 wrong but 6 right,
Hey,
we could use 6 instead of 4.
I listening. I hearing you good.
I think that's a pretty decent strategy. No?
No.
No? Okay.
You closer. You know this. All right. So the multiple choice, let me tell you what the areas they are in. They are in the area of the directors and management. What else? Liquidation. Directors and financial arrangements. And what else I have in? Meetings and resolutions. So I just have to formulate these two last questions for you all. And that's it.
Does it have to be like neatly compiled or listed? It could be listed for some of these questions, or it has to be in a paragraph.
No, some of these can be listed. So let's just see. Let's take the one on the shareholders agreement. Of course, the first part of the question, you're gonna have to write a paragraph or two. The second part of it, where when I say ask you for the provisions, you could list the provision and then just give the rationale why they should be included. The one on the FCSP, that can be a listing. And you could just say why they are required. The one on the directors and the duties, you can list the duties and then explain what the duties are. The one with the section on from the Articles of Association explaining it, no, that one requires an essay. The one I gave you on liquidation, when they explain the difference between the two, the order to distribute, the process, that can be done in point form. The other liquidation question, one can be 3 sentences and some of them can be in points. The one on Byron most likely will be an essay question, and the one on confidentiality will be an essay question. If I don't put it in like A, B, and C and break it down. So I'm gonna write your capstone and send that to you. It'll just be one question.
How long does the capstone have to be? Is it like a 1 page?
No, more than one.
Okay, okay.
Be more than one.
Mm-hmm.
More than 2.
2 pages.
Between 2 and 3. It's not gonna be that
3.
long. Yeah, it's not gonna be that long. This was summer. If we were doing a full semester, real like a long ones, it would be longer.
Okay.
So I will send that to you and we'll go from there. Yeah, I think so. Yeah, so that don't sound too bad, right? I hearing nothing.
I guess not.
No comments.
What do you mean no comments?
No comment.
Oh, Jesus, what is this?
Okay, I did have another question. In terms of submissions that's needed to be in, I know midterm is one, capstone would be one, following the following week. Are there any other assignments that's mandatory to be submitted to kind of contribute to the overall grade of the class?
No, that's it.
Just midterm, final, and capstone?
Yes.
Okay.
That's it. You want some more?
Oh, no.
No, ma'am.
No.
I am right here asking, you know.
No.
I could have given many what you call them things? Homework for y'all to do that could be marked in odd grade, but y'all would have died.
Most definitely.
Y'all was, oh God, it's too much work. So no, and I knew it was summer. So summer's over now. All right, we'll go from there. So I don't think it's that difficult. It's not much. Nothing is there from pre-midterm.
I noticed that actually, that the midterm kind of covered the basics.
Yes.
So I figured the exam would have covered the heavier stuff.
Yes, it did. Yeah, so there's nothing there on the midterm. Mm-hmm. Yep. All right, so I think that's y'all will be in good shape. Just take your time and question. And remember, when a question has more than one part, like when you read a question, the question says, list this, and then it says, explain that. Most students just do the first part and forget the second part of the question. Answer all parts of the question. So that means that when you read the exam, take a highlighter and highlight the action words. Because I find a lot of students lose points like that. When they answer questions, they only answer a part of it and leave the other part. 5 points go on there. Next question, they lose 6 points. Next question, lose another 5. Because they didn't answer all parts of the question.
I have another question.
Mm-hmm. Go ahead.
It's really basic. But I noticed with the IBC Act, in terms of the name of a company, limited liability company is something that's permissible. Isn't that like a name that's like US based?
What you mean?
LLC is normally a term that they use.
Yes. So you ask, is similar?
Yes, or is it the same?
No, not the same in terms of the incorporation process.
Right.
Is in same in terms of is a product that can be incorporated very quickly, and it is used more or less for the same purpose, which is doing business internationally.
So, okay, so any business that's incorporated as an IBC can be used to incorporate, I mean, to do business internationally.
That's what it's mostly used for, yes. For a foreigner would come here, let's say if he's buying property, right, or he just decides to come here, and he finds out from talking to someone that, guess what, you're doing business in Monaco,
mm-hmm,
and why don't you incorporate 2 or 3 companies here in the Bahamas to do your business in the names of those companies.
And you would do that in a completely different country. I mean,
yeah,
you would incorporate here, but the business would be done.
Yeah, somewhere else.
So that essentially means, right? I read that IBC Act, so if this sound dumb, I'm sorry.
No, go ahead.
But that essentially means that any business that is incorporated under the IBC Act can't really do business in the Bahamas. They only could do business outside of the Bahamas. You can do business in the Bahamas.
I'm about to give you the next example. So let's say some foreigners come here and they decide that they want to buy a piece of property on one of the family islands, and they want to build some, I don't know, some resort or something like that.
Mm-hmm.
Sometime in the future. They would incorporate an IBC just to hold that asset.
Okay, but they would be able to operate that business here.
Yeah.
Okay, and I had another question about S Corp.
What who?
Because I know S Corps.
Mm-hmm.
I saw that that's not listed as a ending of the name in the IBC, according to the IBC Act. So does that mean then that in the Bahamas, S Corp doesn't really?
Now, when you say S Corp, what is S Corp? I've never heard of that. What's that?
That's, I don't know.
Spell it.
It's just like S and Corp. It's like a company structure that's normally US based. I see Corp in here, so I was wondering if that was related to that at all. And I don't know if it's similar to like a SA, like a segregated account or what. I don't know.
Segregated account is the SAC.
Yeah, that's what I know, but I was trying to figure out
if you just say SA, that's a society anonymous. That's a different one.
Oh yeah.
But this S Corp. Where you saw that?
Was it S Corp or C Corp? Hold on, wait. Let me just wait. Hold on. Yeah. It's like a yeah, like that's okay, so according to this, and it's like a IRS thing. S corporations are corporations that elect to pass corporate income losses, deductions, and credits through to their shareholders. So it's like I guess like a company structure that's, I guess, done on like for the purposes of what I just mentioned.
Where you looking this up on the internet?
Yeah, but and it's on the irs.gov page.
Okay, hold on. irs.gov plus what it called? SCORP.
Right, small business dash. Well, the dashes I'm looking at is small business dash self dash employed or something like that.
Let me see what this is.
And it's normally mentioned when trying to figure out a structure that they could pretty much evade taxes or minimize taxes. So they choose their structures based off of that. Because there are certain things they would have to pay out in taxes on the basis of what the company structure is.
I'm trying to see what it has to do with IRS. I haven't seen any of these here.
Right. Okay.
I'm trying to see the purpose for incorporating one of these.
Yeah. So looking at it here, it's the S corps. They structure it, or the way that an S corp is structured is to avoid double taxation on corporate income.
Yeah, but that wouldn't be. You wouldn't need one of those here.
Right.
So what Americans normally do is they would incorporate an LLC in their home jurisdiction.
Mm-hmm.
And they would come to the Bahamas and have it registered as a foreign entity so that they can do business in the Bahamas with that entity.
And they would register it as an IBC or?
No, it stays as an LLC.
Okay.
They don't convert it. They just register it as a foreign company to do business here in the Bahamas.
Right.
Yeah, that's what they do.
But I also see like some businesses, they have like co-limited or company limited as an ending to their thing. But that a regular company would probably have that then.
Yes, a regular company, you would see that. You hardly see that in an IBC.
Okay.
They'll just take a name and they'll say Pig Bay Limited.
Mm-hmm.
If they're buying a piece of property and the property name is let me see, Banana Tree Lane, then they would take the name and then create a company name and they'll call it, say, Banana Lane Limited, something close to the name, and then they'll expand on it like that. And every time they buy a piece of property, they incorporate a different name.
Okay. Mm-hmm. Okay.
Let me see. I'm still looking at this S-Corp thing, but that's not applicable here because this is for tax. No, they would normally do an LLC. Yeah, so it says an S corporation is a type of corporation that passes corporate income losses, tax deduction, and tax credits along to the shareholders, all without needing to pay separate corporate taxes. Okay, no, that's for payment of taxes. No. Okay. So the difference between an LLC and an S Corp is, let me see. Oh, ain't much, you know. An LLC and an S Corp still have to file separate tax return. They both have to pass profits to shareholders as dividends. But the S Corp is limited to 100 shareholders or fewer. And for an LLC, it's not applicable. So it's really for those large companies of 100 and more shareholders.
Okay.
This is for big corporation, limited to 100 shareholders or fewer. So this is for large companies. Not for these little 1-man and 2-man bands that come here. Not for that. And remember now, no question is a dumb question. If you're saying things and you don't understand, then you just ask. It's not a problem at all.
Thank you.
Right. So everybody happy now, right? I'm hearing yes, whoopee.
So this, okay.
Mm-hmm.
Yes. But I see the exam day is on the 15th. So it ain't like next week Saturday.
No, it's the week after, right?
Yes. Okay.
Yeah, you have time. Yeah, you have lots of time. And like I say, the exam is not hard. Because we read, the midterm took the first half. I wonder if I should do something on reduction of capital.
No. No.
Alteration of capital.
No. No need.
And take out confidentiality and data protection, which is so easy.
No. Why would you do that? Why
just thinking out loud.
No.
Okay, all right.
No.
The longer y'all keep me on, the more I will be thinking. I would be. Okay.
Today's class was amazing.
No, I think I'll make that. I'll make that the capstone.
Why would you do that?
What you mean it won't be difficult? Come on. I'm only giving you one question. Anyhow, stay calm. I'll think of something. Y'all just don't like shares, eh? I don't know why.
I think that was one of the longest chapters.
Yes, it is. That and directors is the longest chapter. All right. Okay, I'll think of something since you're screaming. But it may just have to be shares. But it won't be difficult. How about that? How about that?
I would answer, but I just want to know what barometer you're using, like in terms of difficulty versus easy.
What
scale?
I know you're working, so I won't do something that will take up too much of your time.
Okay.
But it require you to think first and then write. And then you'll see it's relatively not that bad. But since I know everybody is working, I won't give you something that every night you have to be pouring over.
Okay, that's perfect. Ideal.
Okay, so that's what I'll do.
Well,
I wouldn't do that to you all. No one that is still doing the midterm.
Yeah. Does the capstone require us to pull examples from like case studies or not really? No? Okay.
It might. There's only one question. So
okay.
It may not have to be that long. Or I may just do it whereby you refer to the act itself.
Okay.
Yeah. Like I said, I'll try not to make it too difficult because I know you all are working. And then I don't want you all to come and say you need another extension and another extension. So, no, I'll try to put it within the limits of the time. So that's why I say I'll just do it as one question. All right? Sound like everybody happy now. Why every time you talk about the final exam, everybody's go quiet?
Because it's not open book.
You know, open book is harder, right?
Really?
Yes, it is.
Ooh.
Well, because the first thing is I wouldn't tell you what's coming on the exam. That's the first thing. When you open the book, that's when you can see it for the first time. And you'll have to figure it out from there. And you'll be flipping pages all over the place. I wonder what this is. Oh, hold on. I need to pull the act. Oh, hold on. Let me go look for this. Nah. You already have a coming.
How long is the exam anyway? Like
3
2 hours.
hours. And you don't
3
need
hours.
Yes.
Perfect.
What happened again?
No, that's good time. That's good time.
Yeah, and you don't need all of that.
Mm-hmm.
You don't. Because you're not writing 4 or 5 long essays. You're not writing that. Just make sure you answer all the parts of the question. No need for that. All right. Everybody is happy?
Yep.
Okay, all right. So look out for your capstone question. I'll send it today because I'm going to think right now what I'm going to write.
Okay.
Okay. All right. Study hard, finish all my papers. I'll be checking my box.
Yeah, righty. Thank you.
Okay. All right. Have a good weekend.
See you, ladies.
All right. Bye, everybody.
All right.
Have a good Saturday. Have a great weekend. Bye.
Yeah, you
Thank
too.
you.
Bye.
Come on, no, I'm just waiting for this guy. He used to